morning and welcome to today's Knowledge Bank, Collective Enfranchisement versus RTM. Today's webinar is being hosted by Roger Hardwick and Verity McMahon from Brethetons. If you have any questions throughout the webinar, please submit them via the Q&A button at the bottom of your screen, and we will try to get through as many as possible at the end. The webinar is also being recorded and will be available to watch back via our YouTube channel for anyone that would like to see it again. That's all from me. I'm now going to pass you over to Roger and Verity.
Fantastic. Good morning, everyone, and welcome to Brethetons' latest webinar, Collective Enfranchisement versus RTM. It sounds like some kind of battle, doesn't it? These are two of my favourite topics, and I'm amazed that I've never done this before. I'm amazed that we've never done it before, actually. Yeah. But it's they're very interesting to us anyway. We'll at least try and make it relevant to you. So without further ado, we'll continue with the slides. Before we begin, our usual disclaimer: please bear in mind that what we're going to talk about today is general law only. We're not dealing with any specific facts. If you'd like us to address the particular facts of any case, then please feel free to email either myself or Verity after the webinar, and we'd be happy to address your queries. But collective enfranchisement in particular and the right to manage are often very fact sensitive, so it's important to bear this in mind. Also, the law does have a habit of changing, and we've had the Law Commission's proposals, we've had the government's response, and we're expecting some announcement on leasehold reform in the King's Speech on the 7th of November. So it may be, if you're watching this in a year or two's time, that the law has completely changed. But for now, we're going to deal with the law as it is. We've been saying the law might change for about 5 years now. I think it was about 2017 the Law Commission's consultation began. So, right, next slide. Here we go. There we go. Right, I'm going to leave Verity to make the slides because clearly it's beyond my capacity. Anyway, I'm a partner with Brethetons Solicitors. I deal with residential leasehold property, enfranchisement and property litigation, and Verity is principally non-contentious leasehold enfranchisement and residential leasehold property, where she's a senior associate with us. We're both going to be talking to you today about collective enfranchisement and the right to manage. So what I'm going to do is talk about 4 things. I'll provide you with an initial snapshot of what collective enfranchisement and the right to manage are. I'm going to talk to you about what you get in each case, possibly the most important bit, the property that you acquire with collective enfranchisement and the management functions that you acquire the right to manage, comparing the two. We'll talk about, I'll talk about the right itself to collective enfranchisement and the right to manage, and the eligibility criteria, the conditions that you have to satisfy in each case, comparing the two side by side. Verity will then talk to you about the process, serving notices, receiving counter notices, dealing with tribunals and courts, and she'll also then talk about the cost of each process, and in the case of collective enfranchisement, of course, the price. So in a nutshell, we're talking about 2 sets of rights that apply to leaseholders of flats. So there are a separate set of rights that apply to leaseholders of houses under the Leasehold Reform Act 1967. We're not talking about those. Those give the leaseholders of houses the right to acquire the freehold of a house or a 50-year lease extension. But here we're talking about the collective right for a group of leaseholders of a block of flats to either compulsorily acquire the freehold and any intermediate leasehold interests or leases of common parts through the process of collective enfranchisement, so acquiring the freehold essentially, and the right to manage, which is the process by which the leaseholders would compulsorily acquire control over the management of their building. With collective enfranchisement, the key piece of legislation is the Leasehold Reform Act. The Leasehold Reform Housing and Urban Development Act 1993, for the right to manage is the Commonwealth Leasehold Reform Act 2002. So when I'm referring to pieces of statute, it'll be to those pieces of legislation.
Sorry, Roger, Verity, your slide is just stuck on the first one. I think you might need to play the whole slideshow because it's got stuck back.
Is that moving now?
No.
Okay. Right.
Change back in like the presenter mode.
Okay. Well, it says that the slideshow is currently on.
Gosh.
Should we end slideshow?
It might be because of the different screens. If you continue, and I'll maybe give Emma a call, see if she can come and resolve it.
Has it started again yet for you?
No, I think it's only showing probably the screen that's presenting it on, not the separate screen that it's showing on.
Right. Okay.
Right.
You continue, and I'll give Emma a call, and I'll see if she can come in and fix. Oh no, it's moved now to in a nutshell.
Has it moved?
Yeah. Is this working now, Vicky?
I think so. Yeah.
Yeah.
Can you see
it
the
moving
slide
now?
moving?
No, it's just saying on the in a nutshell slide.
Oh dear.
Okay.
It's okay. You continue talking, and I'll give Emma a call and see if she can pop in and fix it.
Fine. Okay.
Sorry about that, guys.
Right. Well, I'll continue in any case, and we'll get the slides resolved shortly. Anyway, so with collective enfranchisement, what you get is three things essentially. The first and the most important thing that you get, if you correctly exercise your right, is that the freehold of the building or part of a building containing the flats. That's under Section 1, subsection 1 of the 93 Act. The second thing that you'll acquire is the freehold of any additional property that falls outside of the building that contains the flats, and that falls into two categories. So you'll acquire the freehold of any property that's demised to leaseholders that falls outside the building, like garages and parking spaces, for example, or gardens, if they're private gardens that are demised to leaseholders. And you'll also acquire land or property over which leaseholders have rights, so communal drives, gardens, and so on. That will, in most cases, give you all of the property that you need, or the freehold of all the property that you need. The communal property that everyone benefits from, like drives, gardens, and so on, and also the freehold of the block of flats. But there are certain things that fall into a bit of a grey area, like parking spaces over which exclusive leaseholders have exclusive rights. There was a case called Cutter and Pry, in which the upper tribunal held that a parking space over which one leaseholder held an exclusive right technically wasn't something that the leaseholders could acquire the freehold of. My colleagues come to try and hopefully resolve the side issue, and I'm going to carry on talking in the meantime. So I think it's very important when you're setting up the right to manage claim to think very carefully about the property that you're claiming and you're proposing to acquire, because a lot of people get this wrong and they just look at the freehold title and claim everything's edged red on it. And that often isn't the right approach. So you have to apply those three tests: so the freehold of the building containing the flats, the freehold of additional property that's demised to leaseholders, and effectively the freehold of communal areas. You'll also acquire, and this is important, any leases which fall into two categories. So you have to acquire any lease which is superior to that held by a qualifying tenant. So the head lease of a flat, for example, and you may acquire, but you don't have to, any lease of common parts. So that would include, if you had a lease of the communal internal areas, the communal areas that fall within the block, or a lease of a communal gym, for example, or a communal common lounge. But you have to demonstrate that it's reasonably necessary to acquire this lease for the proper maintenance and management of those common parts. So I think it's quite an important thing, because with collective enfranchisement, it is a very well structured piece of legislation, and it pretty much allows you to acquire anything that you might need to acquire to get control over the building, and they've drafted it, with all of this in mind. So it also includes things like leases of air spaces or leases of parts of the wall for advertising hoarding purposes. You'll effectively be able to acquire most of what you need to oust the landlord or landlords and take control over the building. But the landlord does have certain rights. The landlord, if you're claiming the freehold of property which leaseholders have rights over, the landlord can elect not to sell you the freehold of that property, but instead to either grant rights over that property or to transfer some equivalent property that's held elsewhere. So an example of the latter might be, a tennis court. The landlord wants to retain that tennis court, but he's prepared to give the leaseholders another tennis court that's across the road. I've actually never seen that right exercised before. What's more common is where you're collectively enfranchising one building, but it's in a development that contains lots of buildings. You claim the appurtenant land, the communal land that falls outside the building. The landlord says, no, I need to retain that because I'm managing all of these other buildings on the estate. And then he simply grants rights over that communal land rather than selling the freehold of it. So that's something to be aware of, because you won't necessarily be able to claim the freehold of that communal land falling outside the building. There are lots of disputes and cases about the meaning of common parts. This is important for two reasons, one of which is if you're claiming a lease of common parts. Obviously, you can only claim that lease if it consists of common parts. So there's lots of case law about what is and isn't a common part. The Cadogan and Panikopoulos was about a caretaker's flat, and there was previously a lot of debate about whether the caretaker's flat was a common part or not, because there was nothing in the lease that said that the caretaker had to live in a flat in the building, and also nobody had a right to access the caretaker's flat. But the Court of Appeal said it didn't matter. The fact that the caretaker's flat was used for the benefit of the leaseholders was all that was necessary. And there's other case law we'll consider later in the context of the substantial non-residential part exclusion. And the other thing that the landlord can do is to ask for leasebacks of any unit in the building that isn't let to a qualifying tenant. So a commercial unit, for example, you can ask for a 999-year lease of that, or any unit that's intended for letting for business purposes, or actually let for business purposes, or a flat in the building, which isn't let to a qualifying tenant. So if the landlord has a number of flats that are let on ASTs, for example, he can acquire a 999-year lease of those flats. That is discretionary, however. The landlord doesn't have to do that. And if he doesn't, it may be that significantly inflates the price that the leaseholder pays towards the end of the process. And Verity will be talking to you about that. Can we move on, please? By the way, what's happening with the slides? Are they working now?
I hope they're working now. But,
are the slides working though?
Yes, they're all fine now.
Fantastic. Sorry about that. We're very good at the law, but Verity and I are perhaps slightly technologically challenged. So I do apologise for that. So with the right to manage, the right to manage is very different. What you get with the right to manage is control over the management of the building. You don't acquire any property, and that's quite important. The RTM company has no property at all. What it does is it effectively acquires the contractual powers, rights and responsibilities of the landlord and any third party to the lease. So let me talk you through that. The first thing that the RTM company will acquire when they take control of the right to manage the premises is they're entitled to any uncommitted service charge money. So if there's a reserve fund or any service charge money that's held in a general service charge account, the RTM company is entitled to that money as long as it hasn't been committed to costs that have been incurred but not paid out yet. That's the theory. In practice, RTM companies often find it difficult to get this money back. There is a right to apply to the FTT to determine what money should be transferred to the RTM company, but the FTT doesn't have the power to physically order the landlord to transfer the money to the FTT. They'd have to go to the court to get that. Also, all that the FTT can do is to determine what money was in the landlord's account at the day of transfer. They can't determine what should have been in there. So if the landlord has used the money for stuff he shouldn't have used, again, that would have to go through the courts. So in reality, getting the money back can be a bit tricky, but the law is there in theory. So what the RTM company gets is it acquires the management functions of any landlord or any third party to a lease who isn't a landlord or a tenant. And by this I mean any lease of the whole or any part of the premises. So it covers any lease. It could cover a head lease that covers the whole building. It could cover the common parts lease. It covers flat leases. So you look at those leases, and those leases are critical because they determine the RTM company's rights, powers and functions. If the leases are rubbish and don't give the landlord or any third party any management responsibilities at all, that's pointless exercising the right to manage. The RTM company only gets what's in the lease, doesn't get anything else. There was a case called Wilson and Leslie Place RTM Company Limited, which emphasised that point. So you look at the lease and whatever management functions the landlord has under the lease and whatever management functions a third party like a management company has under the lease are transferred to the RTM company when it acquires the right to manage. And management functions means functions with respect to services, repairs, maintenance, improvements, insurance and management. The last bit's a bit circular, but for the most part, this is clear. So any obligation in the lease on the part of the landlord or an RMC to maintain or insure the building will transfer to the RTM company. There are other ththings which aren't so clear, like dealing with notices of assignment, for example. I think those arguably transferred to the RTM company. There's no case law on yet. The RTM company doesn't acquire functions which relate to forfeiture or re-entry. You would have thought that's obvious because it's not a landlord, but it's specifically spelled out in the legislation. It also doesn't acquire any functions that concern only units which are not let to qualifying tenants. So if you've got a function that is exclusively related to commercial units, for example, that will not be transferred to the RTM company. But anything that's shared, any function that relates to both resi and commercial will transfer. So landlord can enforce RTM company obligations. So any obligation that the RTM company acquires under Section 96 can be enforced by the landlord. The landlord / RMC / third party isn't, well, once the RTM company's acquired the right to manage, that they can't do anything which falls within the functions of the RTM company. They're not allowed to unless there's been a prior agreement with the RTM company. So that sort of opens the door for the RTM company delegating back some of its functions to the landlord. Section 97 subsection 4 provides for the transfer. I mean, effectively, this is about service charges. It's broader than that, but it effectively gives the RTM company the right to recover service charges from leaseholders in the building. And then you have sections 98 and 99, which deal with the transfer of functions relating to approval. So what we're talking about here is licenses to assign, licenses to alter, licenses to sublet, etc. Anything involving the consent of the RTM company. And this also covers anything that relates to the granting of certificates for the purpose of dealing with a restriction on the proprietorship register of the official copy, so land registry consents, essentially. There is a process that has to be followed for this, however. It's not just a case of the RTM company granting consent, because the RTM company has to give notice to the landlord or RMC, as the case may be, before it can grant consent under the lease. And the notice period depends on what you're dealing with. So if it's an assignment or subletting or alteration or improvement or change of use, then it'll be a 30-day period of notice. For anything else, so consenting to animals, for example, it would be 14 days. If the landlord objects, then or the RMC objects, then the RTM company can only grant consent if the landlord later consents or they apply to the FTT and the FTT said it was unreasonable for the landlord or RMC to withhold consent. The RTM company can enforce any of the covenants in the lease, whether or not they're technically within its management functions. The one thing that you have to be, I think perhaps one of the limitations of the right to manage is that it doesn't necessarily stop the landlord from developing the building. So there was a case called Francia and Aristu where the landlord wanted to construct a flat on top of a block of flats. RTM companies said you can't do that because we need to maintain the building, the roof and so on. But the court disagreed with them, essentially said that unless what the landlord is doing is substantially interfering with the RTM company's functions, he's still free to develop the building as he sees fit. So what about the benefits and advantages and disadvantages of both? For collective enfranchisement, I think one of the main benefits is that the nominee purchaser, so that the company that buys the freehold on behalf of the leaseholders, can grant new leases, usually 999-year leases, to the leaseholders at a peppercorn ground rent. And if the leaseholders are dealing with the building and they've got short leases or leases that they want to vary for some other reason, then the ability to grant new leases is one of the main driving factors before to exercising the right to collective enfranchisement. You also get full control over the building because the nominee purchaser owns it. So you wouldn't have to worry about a landlord developing the property if that was something that was concerning you. But also because you own the property, it's easier to do parking enforcement, for example, because you own the land. It's easier to sue somebody for trespass if they're misusing the land in some way. You just have more options available to you. You have full control over licenses and consents, which you don't get with the right to manage. And I've also found that with collective enfranchisement, landlords very rarely oppose. I think in the 17 years that I've been doing this, I can count on both my hands the number of times that a landlord has actually opposed a collective enfranchisement claim. But by comparison with the right to manage, they're almost always opposed. Even if the landlord has no chance of winning, they'll still oppose it to delay it often. So I think that is a sort of a practical factor to take into account. But with the right to manage, this is a benefit for later on actually, but it's a significant one. I'll deal with it now. You don't have to pay for the right to manage. You don't have to pay a price for it. So it usually costs significantly less. And with the right to, if the only thing you want is control over the management of the building, then the right to manage is probably going to be the better option for you. And it's essential where there's a third party that has management responsibilities. So if you've got an embedded management company, it's a management company that isn't owned by the leaseholders in the building, for example, that is a managing agent that's been written into the leases, collective enfranchisement isn't going to help you because that will only put you in the shoes of the landlord. It won't get you the management responsibilities of the third party. So in that case, you'd have to exercise the right to manage. So the right, what I'm going to talk to you now is essentially about the qualifying conditions, how you qualify for the right to manage collective enfranchisement respectively. And they're very similar. They were drafted to be similar. With the idea that leaseholders would go for the right to manage first and then collectively enfranchise, although typically it doesn't happen that way. So with collective enfranchisement, there are three principal conditions. It's also this way mainly for the RTM, and I'll talk to you about that later. But the first is that the premises that you're claiming the freehold of has to either consist of a self-contained building or a self-contained part of a building. So it has to be one of those two things, okay? It will be a self-contained building if it is structurally detached, and structural detachment is determined on a fact basis, so it's all about the degree of structural attachment. In a case called Number 1 Deansgate Limited and Number 1 Deansgate RTM Company Limited, in that case, two buildings were connected by a bit of plastic weathering, and the landlord sought to rely on an earlier House of Lords case that had said that you had to have complete detachment from any physical structure to be structurally detached. But the upper tribunal distinguished that case and said no, it's about degree of attachment, and attachment by a bit of plastic weathering is not structural detachment. Albion Riverside Residential Limited and Albion Riverside RTM Company Limited was a case about an underground car park, which is a very common issue when you're trying to decide whether a building is structurally detached. If you have buildings that are connected by an underground car park, then neither building is structurally detached, but together they may collectively be one structural unit. Palgrave Consensus was another one about an underground car park where you had 5 buildings on top of this underground car park that were all capable of standing on their own, but because the High Court decided that they were attached by the underground car park, therefore not individually structurally detached, but collectively one structural set of premises. If the building, if you're claiming a self-contained part of a building rather than a self-contained building, it's got to satisfy 3 conditions. The first is that it's got to be divided vertically, and this means a clean vertical line. Any degree of deviation will prevent it, apart from de minimis, a very, very minor deviation, will prevent it from being divided vertically. There was a case called Solitaire and 116 Finland Street, RTM Company Limited, where a 2% variation was held to be sufficient to mean that the building wasn't divided vertically. It's got to be capable of independent redevelopment, which means that you should be able to demolish or substantially reconstruct your part without affecting the other part that it's attached to. Rows of terraced houses probably fall within that category. And then you've got the third, which is that the services that are provided to that part, and services specifically defined as anything that's transmitted by a pipe or a cable or anything like that. So we're talking about water, electricity, sewage. That the services are either provided independently or could be provided independently without significant interruption to those services. And there's a couple of cases on that, both of those Oakwood Court and St Stephen's Mansions, and both of them deal with water and water pumps, and whether it's, you could separate the water pumps without significant interruption to the part that you're claiming. There's a case called Craft Rule and 41 to 60 Albert Street, I think, where the argument was where you can claim a self-contained part of a building, you have to claim the smallest possible unit. You can't claim multiple self-contained parts in one set of premises, but the court in that case held that you could, so you're not obliged to go for the smallest unit imaginable. So that all deals with the first of the conditions. The next two are that the premises have to contain at least 2 flats which are held by qualifying tenants, and at least 2/3 of the flats in the building have to be held by qualifying tenants. And what we mean by a qualifying tenant, in the most part, is going to be a lease which is granted for a term exceeding 21 years. There are other types of long lease, and I won't go into them all because some of them are quite obscure. But I will say that there are types of excluded tenancy. So if you own a lease which is a business tenancy under Part 2 of the 54 Act, that will be excluded. And also a landlord, if your landlord is a charitable housing trust and the flat forms part of the housing accommodation, it will also be excluded from being a qualifying flat. Importantly, because this isn't in the right to manage legislation, if anyone owns more than 2 flats in the building, they won't be a qualifying tenant of any of them. And that includes if they're a co-owner with anyone. It also includes associated companies, which are defined in a very particular way. But it is possible to avoid this. There was one of my favourite cases, and this makes me very sad, but it's still one of my favourite cases, a case called Westbrook Dolphin Square of Fens Life, where one company owned what I think was 1,023 flats, and they really wanted to collectively enfranchise. So they set up more than 600 companies and transferred 2 flats to each company and structured the companies in such a way so that none of them were associated. I think they had a 50% was held in some Jersey discretionary trust, and the other 50% was held in some other company. So none of them were technically associated with one another. And they avoided the multiple flat exemption in that way. I imagine that would have been immensely expensive to do, but I think the price in that case was over 100 million. So it was, it was a really big, valuable claim. You'll probably have recently come across the Avon Canary Gateway case on shared ownership. It was very prominently reported in the press. So you can be a qualifying tenant of a flat if you own a long lease of a share, which is a shared ownership lease with you haven't staircased to 100%. So whether it's 25%, 50%, 75%, you can still be a qualifying tenant of a flat. We know that there was a case called Brick Farm and Richmond Housing that determined this long ago, but it's recently been in the Supreme Court in the case of right to manage, in the case of Avon and Canary Gateway. So this opens up the right to shared ownership leaseholders that haven't staircased to 100%, which is obviously good news for the leaseholders. I believe there may be an appeal to the Supreme Court though, so watch this space. There are three types of property that are excluded from the right to manage. You've got the most common one is premises which have non-residential parts which exceed 25% of the total internal floor area of the premises, which excluding common parts. So what you have to do is to take common parts out of the equation and measure the residential bits and measure the non-residential bits. And if the non-residential bits exceed 25% of the total, then you've got the properties excluded. Non-residential doesn't necessarily mean commercial. Non-residential is defined as something which isn't a common part and isn't residential or isn't occupied for residential purposes. So it's not one of those two things, common parts or residential, it will be non-residential. There was a case called Connaught Mansions, which was about some underpavement vaults which belonged to the landlord. So although not technically commercial, they were non-residential because they weren't a common part and they weren't occupied or intended for occupation for residential purposes. So landlords' voids may fall within that category. You might end up having arguments about whether or not those voids are common parts, and that can be potentially where the arguments of the grey areas lie. Premises including the railway track. I've had one in the last 17 years. I had one. It was a London Underground case. Usually the railway track has to be connected to the structure of the building in some way. And a property that falls within the resident landlord exemption. So this is slightly different from the RTM's resident landlord exemption. It's very rare in practice because you have to prove that the landlord had owned the freehold since before it was converted to flats. So this usually applies, it can't apply to purpose-built blocks of flats. It can only apply to houses and the like that have been converted into flats where the landlord has owned that building since prior to its conversion, and in the last 12 months ending with the date at which the claim is issued, the landlord or an adult member of his family has occupied the building for as their principal or only home. I mean flat or unit within the premises rather than building. With the right to manage, the qualifying conditions are very similar. Self-contained building or part of a building, the same thing applies. The only slight difference there is a reference to permanent property, which I'll come on to. At least two flats held by qualifying tenants, 2/3 of the flats of the premises have to be held by qualifying tenants. All of that is the same. The main difference is that the RTM company will not acquire the right to manage any appurtenant property, by which I mean communal land effectively falling outside the building, where that property is shared with other buildings. It will only acquire a pertinent property which exclusively benefits the occupants of the building that you're claiming. I should probably also mention at this point that the RTM is exercised by an RTM company, which is a special purpose-made vehicle for exercising rights to manage, whereas as Verity will talk to you about shortly, with collective enfranchisement, you can incorporate any company to acquire the freehold. However, one of the qualifying conditions in a case called 90 Broomfield Road is that the RTM company can only acquire the right to manage one building or self-contained part of a building, in contrast to collective enfranchisement, where although you probably have to serve separate claims, the one company can technically be nominated as the purchaser in all of those claims. So going back to a pertinent property, you can only claim communal land that exclusively benefits the building you're acquiring the right to manage over. There's no multiple flat exemption. So in the case that I mentioned, Westbrook Dolphin Square, had he gone for the right to manage, it wouldn't have mattered that he owned over 1,000 flats in the building. There's no exemption for flats that have landlords that are housing trusts. They're not excluded from being local. They're not excluded from being qualifying tenants under the legislation. The question about whether you have to claim the smallest unit is going to be decided by the Court of Appeal in a case called Asset Holder Evelyn Road RTM Company Limited. So watch this space about that. They're trying to distinguish craft rules, so that could potentially be something that's different from from collective enfranchisement. And the exclusions are broader with the right to manage. There's more of them. So it has the 25% non-residential exclusion, which is very similar. Doesn't have the railway track exclusion, but it has other exclusions like any building where there's a local housing authority landlord, or a building where the right to manage has previously been exercised but folded for some reason. Then you can't claim the right to manage again for a period of 4 years without the consent of the FTT. So where are we? Right, we're on the last slide. I'm going to give you just under 25 minutes, Verity. In terms of qualifying, it's probably easier to qualify for the right to manage because you don't have to worry about the multiple flat exemption. But one of the benefits of collective enfranchisement, of course, is that you can claim the freehold of communal land, whereas with the RTM, you won't acquire anything other than communal land which exclusively benefits your building. So again, which one you go for will depend on what you're trying to achieve. I imagine RTM is going to be easier and more attractive in cases where you've just got one building. If you're dealing with large developments, then it may be that the kind of right side of things it's better with collective enfranchisement. But each case has to be considered on its own merit. So I think that's me done, Verity. So I'm going to hand over to you to talk about the process and costs.
Oh, okay. So now that Roger's covered the rights and the benefits surrounding that, I'll cover actually how you go about doing that under the legislation. So I would say before this, there is a pre-preliminary stage of obviously gathering the participation in the adequate numbers with both the collective enfranchisement and the RTM. You need 50% of qualifying tenants to participate. That can take some time in itself, especially with larger blocks. And there's many ways that you can do that, such as getting a project manager involved, getting a solicitor involved to gather information, door-to-door, residents committees, etc. And before any of this as well, we always, as solicitors, suggest that you instruct a surveyor, a specialist surveyor, to go and inspect any of the blocks to check that they definitely qualify, as Roger has gone over all the exclusions in terms of commercial property and floor space, etc. And as well, more importantly, to assess the value that you have to pay for the block of the flats. They usually give a range of figures, a low figure, a high figure, and an opening offer. Therefore, before we start anything, the leaseholders are going in with an open mind and know what to budget for this whole process. Once everyone's happy with that, we've got adequate numbers and we are ready to go and we are confident that it qualifies, we will go ahead and incorporate the nominee purchaser, which, as Roger said, is the vehicle that we use to purchase the freehold of the block. This can be done in one of two ways. You either incorporate a company by which you will serve the notice under the company's name, or the leaseholders will then take a share in that said company and you will continue in that way. Or you don't have to set up a company if it's a smaller block. We sometimes draft a trust deed if it is that you want to set up in individual names and own the property in individual names, and the trust deed will set out the conditions of that. We always recommend as well entering into a participation agreement, which is essentially a contract that binds all of the participating tenants together and sets out their obligations moving forward once the initial notice is served. This can cover anything from a leaseholder dying to a leaseholder selling during this process, because it is quite a lengthy process and things do change. So, for instance, if they sell, it obliges the new owner to step in their shoes and continue with the cost obligations surrounding this. It also sets out the apportionments that each leaseholder will pay. So, for instance, if you've got different sized flats in a block, some might be 2 beds, some might be 1 bed, they all pay a different percentage of the price that will eventually be paid. So it sets out all agreements in advance, so there's no, hopefully, disputes as we go through the process. And if there is any disputes, that's what we will fall back on. If we need to find out information about the freeholder, sometimes it's not overly clear. They can be missing, which is a whole different process. They can not serve ground rent notices. They could just be a bit absent. It could be that we're not entirely sure what addresses we need to serve the notices to. It could be they've got multiple managing agents or people dealing with the block if it is quite a complex block. We will serve a Section 11 notice, which is an information notice to obtain service addresses, and clearly sets out who the freeholder is on the development. And a response, the landlord has to respond to that notice within 28 days. So hopefully, if there is any doubt about the address where we have to serve, we should have total clarity before that initial notice goes, because there obviously are quite severe consequences should that notice be invalid. So once we've got all our preliminary stages done, we are ready to serve the initial notice, which is in itself in a prescribed form. This is vital that it is correct, and it's vital that a specialist is appointed, which I'm sure we all know in this industry. Things can go wrong with notices. They can be invalid. Any discrepancy with the notice, especially if the freeholder does not want to sell the freehold give the freehold to the leaseholders, they will pick up on it if it is that they have a specialist acting for them on the other side. Whilst Roger said opposition is a little bit lower in collective enfranchisement, it's still possible. So it needs to be to the T. As well, once we've served the initial notice, after that point, we give the landlord 2 months in which to respond with their counter notice. So the initial notice will usually set out our opening offer, which would have been advised from our specialist valuer. And in the counter notice that we expect from the freeholder, we usually expect it in the high end, if not higher than the valuer's estimate. Between that time, they can ask us to deduce title, which is proof that the leaseholders have right to buy the freehold in itself. So we will get on with that and serve all the appropriate office copy entries. They can also inspect as well to check themselves if it qualifies. They will appoint their own valuer, and they'll do a similar process to what we did before the preliminary stage. Once they serve their counter notice, I would say as well, always allow time for postage. So don't just put 2 months within your initial notice. Always make sure you allow time for postage, because that in itself is a bit of a rookie error and can mean that your initial notice is invalid because it's the day that it's served. Once we get the counter notice back, this will either admit or dispute our initial notice. Hopefully, if you've done everything right, it will admit the claim, and you will know your freeholder's position. So you'll know the price they want, you'll know any terms that they want to include within the transfer document, which will transfer the property to the group of leaseholders. In very, very rare circumstances, and me and Roger were talking about this just before we came in the meeting, I don't think I've ever had one.
No, I've never had
one.
one.
So there you go. It's very, very rare. They can come back to say that they want to redevelop the property. To do this, 2/3 of the leases in the property have to have a term less than 5 years, and the freeholder has to prove that they are demolishing or redeveloping the block, and as a result, they need the leases, and they need to be in possession of the leases. So once that counter notice is served, we will have 6 months in which to negotiate what we call the terms of acquisition. Now, that's just the fancy way of basically saying the price payable for the freehold of the block and the transfer terms, so the terms contained within the transfer document that will be transferred over to either the freehold company or the tenants themselves. It's really important to keep to that 6-month deadline. If you do not, there are dire consequences. So we have that in every diary that is possible. it gives, I'm sure it gives all of us practitioners anxiety and sleepless nights sometimes. So make sure that is definitely kept to. If you miss that deadline, deemed withdrawal means that the claim is completely lost and you have to start all over again. And also the tenants won't have the right to do this again within the 12 months of deemed withdrawal. So it's not good. If it is during this time, you will have your valuer negotiating the premium that's payable for the block, and the solicitors will be negotiating the transfer document, both of which kind of run simultaneously, hopefully. That's the ideal situation. Now, both of these being agreed, so it could be that your premium's agreed first and you haven't quite agreed the transfer document. It's on when the final one is agreed that the terms of acquisition are then agreed. So you've got to be really careful of that date. If it is that you can't agree them within the 6 months of the counter notice being served, you have to apply to the first tier tribunal where terms are still in dispute. So if both valuers, the freeholders valuer and the valuer acting for the leaseholders, just cannot come to an agreement, it's always worth applying to the FTT. You have to do that within the 6 months, or as I mentioned, that's deemed withdrawal, which is not good. If it is both the price payable and the transfer terms are agreed, this will set a new deadline of 4 months from that agreement, which means you will have to exchange or complete or apply to the county court for a vesting order within 4 months. So basically, once terms are agreed, you've got 4 months to complete it. Again, otherwise that's deemed withdrawal. So if it is that you're getting close and close to that 4 month deadline, and it is that the freeholder is just freeholder solicitor or the freeholder themselves are dragging their feet and you know, we can't get matters wrapped up, it is vital that that date is kept to. We will then look at the terms of conveyance and transfer. So that's what the solicitors do. Obviously, that includes any easements that need to be kind of kept to, any covenants that the landlord wants to keep if they have like retaining land or anything like that. Leasebacks, which Rog touched on, this will be if the landlord retains a flat in the block, they will have a lease back of that flat. That is optional, so you have to bear that in mind when it comes to price. It could be that they want to get rid, and that will then obviously inflate the price.
Or commercial units.
Or commercial units, yeah. And then after we've done all of that, and hopefully we've completed with no issues, and hopefully you won't even have to apply to the FTT, but there you go, or the county court. We will take care of any service charge management arrangements. That usually is done during the process by your appointed managing agent. So it could be that you will tender managing agents during this process if you want a new one. It could be that you already keep the existing one, and they will usually take the management arrangements off the existing managing agent. So right to manage, again, this is similar to the preliminary stages. There is a bit of time that, especially with bigger blocks, that will need to be taken to obtain the 50% that is required. You know, that can take however long it does. It depends on the motivation of the leaseholders involved, but managing agents usually help with that, and again, project managers.
I think the key one with that is that the preliminary stage is that you have to exercise the right to manage through the vehicle of an RTM company.
Yeah.
You can't, unlike collective enfranchisement, you can't pick anyone to be the nominee purchaser. It has to be a company with a prescribed set of articles of association.
So yeah, as Roger mentioned, so it's very prescribed. You have to have prescribed articles, can't vary from them. We find with RTMs, which I'll go on to in a minute, that they do get objected to and opposed a hell of a lot. So if it is that you're varying from these articles, that will 9 times out of 10 get picked up on. So it has to be a very specific structured company. Again, if it is that we don't know much about the freeholder, there is a process where we can obtain more information, and they have to respond within 28 days of this. So if it is that we're not quite sure where to serve the notice to, because that is vital, we would serve a Section 82 notice on everyone involved so we can get that information. The same with requests for access. If it is that access is needed, that's not less than 10 days, I think, that they
yeah, I mean, but you wouldn't normally require access unless you wanted to measure parts of the building to determine whether or not, you know, the residential, the non-residential exemption applied.
Yeah.
And the Section 82 requests are very kind of limited in what you can ask for. Essentially, you can only ask for stuff that you need to put in the claim notice. You can't canvass them for information that you need to, you know, to write to everyone in the building to get the claim moving to start with.
Once we've kind of got all our preliminary in a row, we would serve our notices of, and the company incorporated, we serve notices of invitation to participate, and they would go to any of the tenants that aren't participating in the RTM. We have to do this in order to be compliant with the RTM process. Again, they're in a prescribed form, so we have to make sure they are sent as prescribed under the Act. And we have to attach the articles of association and or give a place where they can be inspected. So that's another kind of rookie mistake that tends to be made. This will usually contain details of the RTM, what's happening, and give the non-participators 14 days in which to confirm that they want to participate or not for the purposes of the claim notice moving forward.
Well, I think Verity and I both found this to be a bit of a nightmare.
Yeah, with bigger blocks.
When you're dealing with multiple blocks of sort of 100, 200 flats, you have to download official copy entries the day that you serve the notice of invitation to make sure that you're serving them on the right person. And sometimes flats are in the process of being sold, but you don't know who they've been sold to.
Yeah.
And you know, you get it wrong. You fail to serve notice of invitation on one person that isn't a member of the RTM company, and it can invalidate the whole claim. So this is probably a major drawback, I'd say.
I would say so. Yeah, it can be very admin heavy before the claim notice is served. To be honest, I would say most of the work in terms of the admin is before we've even gotten served the notice. There's so much to do, especially with bigger blocks.
Thankfully, the Law Commission have proposed that this is removed as a process,
which we will all celebrate.
Yeah, pop open the champagne.
So again, once we've served those notices of invitation to participate, and we've got either the replies or no replies at all, we will then, 14 days after, we will serve our claim notice, you know, to say to the landlord that we want to acquire the RTM, and that will come from obviously the RTM company. This again is in a prescribed form, and again allow time for postage on this. We need to make sure that it's adequately served. So make sure the dates that you put within the claim notice reflect that. So the counter notice needs to be replied to, the landlord needs to give a counter notice within 1 month of the claim notice being served. So just make sure that there's adequate time for that. Once the counter notice is served, they will either admit or dispute the claim for the right to manage. We normally find that it's often disputed. It is very admin heavy, and I do think sometimes freeholders know this, and they'll always take advantage of the fact that we have to have everything lined up before we even get to the point of serving the claim notice. They will require evidence of that. Again, as Roger mentioned, that includes land registry, office copy entries, that includes sending them proof of all of the membership forms, notices of invitation to participate, articles. So it can be very, very admin heavy, especially with bigger blocks. It's very stringent on process, which is a downfall.
I don't know about you, Verity, I've actually only ever received one counter notice admitting the claim.
Yeah.
I've had landlords sometimes admit the claim later on.
Yeah.
But I've only received one counter notice admitting the claim. The more common is that they don't respond at all or dispute it.
Yeah.
Majority dispute. And then,
I would say the majority dispute. Yeah, mainly because they don't want to give up the management of the block because it can be quite profitable, obviously, to them. So if it is that we, So if it is that the claim is disputed, we will make an application to the FTT. This will determine roughly when the acquisition of the RTM is actually acquired. So there's kind of 3 scenarios really as to when it can be acquired. It's where the counter notice is served admitting the claim, or no counter notice is served whatsoever. It's nice and simple, and it's acquired on the date specified in the claim notice. You are very lucky if that happens.
That can't be any less than 3 months from the date specified in the claim notice for the service of a counter notice. So if you've given 1 month for the service of the counter notice plus 1 day usually, then you specify a date for acquisition of the right to manage, which is 3 months plus 1 day. By the way, those are, I think it was Kenley and Windermere Court determined that how the dates work, but essentially you have to add a day to it. Yes, so probably the earliest you'll acquire the right to manage is sort of just after 4 months from the service of the claim notice.
Yeah, we roughly say about 4 months. If your counter notice is served disputing the claim, but the claim is later admitted, so it could be that you go through this whole exercise of proving that you do have the right, you've done everything legitimately, and then they realise that they don't have a leg to stand on when it comes to the FTT. It's 3 months from the date of written admission from the freeholder or their solicitor. Where the counter notice is dispute and the claim goes all the way to the FTT, and it determines that the RTM company is entitled to acquire the right to manage, it's 3 months from the date of the decision becoming final. So essentially, after appeals are exhausted, the whole process in terms of the FTT is completely exhausted, and you've got the final decision.
Well, I meant to put on these slides, but forgot that you have to make the application to the FTT within 2 months of receiving the counter notice.
That is important.
Otherwise, if you don't, then the claim is deemed to be withdrawn. But unlike collective enfranchisement, the right to manage, if your claim is deemed to have been withdrawn, you can reserve it immediately afterwards. Whereas with collective enfranchisement, you have to wait 12 months.
It's quite severe, isn't it? So, in terms of the process, what the benefits are. So, collective enfranchisement, leaseholders can nominate any person or any company to purchase their freehold. So it's not rigid like the RTM. It doesn't have to be in a specific form, specific articles. It doesn't have to be block by block. It can be multi-block. If it is that you've got various blocks on one estate, it could be that you use the same company to purchase each block. There's no need to serve notices of invitation to participate, which, as you probably gathered, is a bit of a pain. So it tends to go a lot quicker in the preliminary stage, and the notice is served a lot quicker after that. And the landlord, is that in the right place? Oh yeah. So yes, that's the point. So landlord embarks on a trench welfare to frustrate RTM claims, which is from who?
I think it was Lord Justice Lewison and Elam Court. I mean, as we said before, landlords routinely dispute RTM claims.
And it can take months, take a while. Benefits of RTM. So, as Roger mentions, RTMs can reserve claim notice immediately after a deemed withdrawal. So there's not as severe of consequences should it be that you need to reserve a claim notice for whatever reason, if it is disputed on a certain point. And it can be quicker. It doesn't sound like it from the way that we're conveying it, but it can be quicker if it's not contested. And we usually find it isn't contested on smaller blocks. It's usually the bigger blocks, prime central London, that tend to be more contested than that of, say, a block of, 8 to 10, So it all depends on the block, really. The
one point, actually, that it's just occurred to me that I should have put down for benefits of RTM, that it's quite an important benefit, is that all of the leaseholders can apply to be members of the RTM.
Yes.
Any qualifying tenant of a flat can apply to be a member of the RTM company. Whereas with collective enfranchisement, you can exclude groups of leaseholders.
Yeah.
So you sometimes find it that you've got one group that's majority, maybe you've got 10 flats 6 of them club together and they hate the other 4,
Yes.
and they collectively enfranchise and deliberately exclude those 4 flats.
And then won't let them in.
And won't let them in. So that I think probably is a drawback.
Yes. Yeah, collective enfranchisement works. There's like a good neighbourly vibe, really, doesn't it? So how long does this all take? Now, I would add probably to these estimates about 3 months in which to gather participation, to have the evaluation report done. This is probably from the service of the notice and incorporation of the companies. So collective enfranchisement, approximately 8 if you're very lucky. If it's a smaller block, there's not many complications. 12 months to complete, provided, as I mentioned, the leaseholders are organised. And there's 2 elements that need to be agreed: is the premium and the terms of the contract. Right to manage takes a lot less time because you don't have a lengthy negotiation period when it comes to the premium or the terms that are involved. Price is the thing that matters mainly in collective enfranchisement. That is what's most important. RTM, there's no consideration to pay to your freeholder, so it's approximately about 5 to 6 months to complete. I would put this, provided there is no disputes or no FTT.
I love the caveat at the end. If the landlord disputes and it ends up going to the FTT or even an appeals process, it can be dragged out for years.
Yeah, but, especially in the state that the FTT and the courts are in at the minute, it takes a while.
I'm conscious that we've just crept over the 1 hour mark, so if we can rattle through cost and price, I think.
So. Price payable for the freehold. So this will mainly be down to your valuers, but it's calculated by capitalised value of ground rent, value of reversion, marriage value. So that will happen if the leases within that block or some of the leases are below 80 years, marriage value will become applicable. And any development value. So if it is that you've got a flat roof and can build upwards, if it is that there's common areas where you could essentially build on, that needs to be taken into consideration and the loss of that. Any lease backs as well will need to be taken into consideration, which we haven't put on there. But if it is that the freeholder doesn't want to take lease backs and they retain some flats in the development, then we need to add that into the price. The
value of the reversion, in case anyone's wondering, is the value of the right to take possession of the flat when the term expires, essentially.
There are certain costs recoverable by the landlord. So you also have to pay their reasonable costs. Now, they do have to be reasonable, which I'm sure is different from where it is, the experience of the solicitor that's dealing with it. You can make an FTT application to determine costs if it is that they come with very wild prices, but they are limited to costs of investigating the claim, and serving the counter notice. So investigating the initial notice and the counter notice, serving the counter notice, the initial valuation, and the transfer document transferring the freehold to the tenants. The main difference between collective and RTM is they cannot incur costs in connection with any tribunal proceedings. So that is normally a point where we find within a collective enfranchisement claim, if it is that it's dragging, that the freeholder will tend to be responsive, because the minute we issue an FTT application and when they issue directions, that's when they start having to put their hand in their own pocket for their solicitors and valuers' costs. Yeah, so right to manage, there's obviously no price payable to the landlord, which is a plus, because then you don't have to have big financial obligations on the leaseholders. The landlord, again, is entitled to recover reasonable costs as a consequence of the claim notice. So reviewing the claim notice, serving their own counter notice, either admitting or disputing. Costs incurred with, this is the main difference, as I mentioned earlier. So any FTT proceedings, if the landlord defeats the RTM claim, which hopefully they won't if everything is done correctly, but if they do, just bear in mind that they can recover their own costs if it is that it is defeated in the FTT.
And those costs, and this actually applies to both collective enfranchisement claims and the right to manage, those costs are not only recoverable from the RTM company or the nominee purchaser, they're also recoverable from any participant in the process, individually, jointly and severally. So I had a case where my client defeated an RTM claim, and the costs, I think, were recovered entirely from the director leaseholders because they were the only ones that could pay.
Yeah.
It was about 26 grand. So, you know, just bear that in mind if you are pursuing a claim.
And some quick benefits surrounding the cost and the price. So with collective, the costs incurred in connection with an FTT proceeding never recoverable, so parties will pay their own. And obviously, the grant of a new 999-year lease extension post-completion. Now, the reason I popped this in the cost and the pricing is essentially if a leaseholder wants to exercise their right to a statutory lease extension, it roughly equates to their portion of how much it would cost to purchase the freehold. So if it is that it's really organised and you've got kind of more or less full participation with an investor or someone putting in a little bit more, you actually get more for your money because you're only entitled to a 90-year lease extension for when you exercise the right to a statutory lease extension. But you become your own freeholder here. So members, normally what we often find is grant themselves a 999-year lease extension, get rid of any ground rent, make sure there's no nasties in their lease, and it's really saleable. Benefits of an RTM claim. Main one, there's no compensation payable to the freeholders, and we usually find that legal costs tend to be cheaper because there's no lengthy negotiations. That sums it up. So which is best?
It depends. Yeah, I mean, essentially, if the leaseholder's main objective is to take control of the management of the building, then it's likely that the right to manage is going to be the best option. But again, it depends on the facts. So with collective enfranchisement, if they're really keen to acquire control over external communal areas that fall outside the building, maybe collective enfranchisement is a better option. If they want more control over the building, which the right to manage won't give them, or they're very keen to grant new extended leases, then it's going to be collective enfranchisement. So I mean that is it in a nutshell. But each case has to be considered on its own merits, depending on the factors that we've just discussed to you. So it may be that you think, well, actually, if we go for a right to manage claim, the landlord will almost certainly dispute it. But if we collectively enfranchise, we'll pay him off and he'll accept the claim. So that might be a factor. Personalities are also important. Yeah. We've crept over a little bit, conscious of that, but thank you for bearing with us.
Yeah, thank you.
And I love the little unicorn. I missed that. I cracked a joke when I was drawing up the slides to Charlotte, who does all of our PR. I said, you put some pretty pictures and unicorns on it. I was joking, but she's
taken it quite literally.
So, do we have any questions, Vicky?
Yes, we've got two questions. We'll just see if we can get through them. So the first one is, they've not left their name, but they said they manage a building with an RTM company and external repairs are urgently needed. When approaching the RTM company for their consent to proceed, they advise that they're only responsible for the renovation of the internal parts of the building. How can they know if that's really the case or not?
Right, so
quite specific.
Does this person act for the RTM company? Do they say that they're acting for the RTM company?
No, they've not said. They've just said they manage a building within an RTM company.
Will acquire all of the management functions that belong to the landlord and any third party to the lease. That would normally include the management of the whole building. You might have a situation where an RMC has only control over the internal parts, and the landlord or a different RMC has control over the structure, but that's different from an RTM company. Normally an RTM company takes everything. So I'd be surprised if an RTM company, which has exercised the right to manage, doesn't have control over the structure of the building. That would be very unusual. That would only be the case if the leases themselves contained nothing, no obligations at all relating to the structure, which I think would be very surprising and probably means the leases are defective. I imagine that I would need to check the leases, but I imagine if it is an RTM company and not an RMC, that the RTM company has control over the whole building and the responsibility to renovate, repair the structure, the exterior, the whole building, and not just the internal parts. But happy to look at the lease and advise further if necessary.
Okay. We've got another question from Fraser. He says, do all the costs for the RTM or enfranchisement have to be paid via the participants?
Yes. You can't put them through. Well, you can't put them through the service charge unless, and you wouldn't be able to anyway, unless you acted for. Well, you could theoretically try to put it through the service charge after you'd acquired the freehold or the right to manage, but you're unlikely to be able to do that unless the leases allow you to do it. I've come across one, maybe two leases that specifically allow the landlord to recover the cost of buying the freehold through the service charge. All of the others, there isn't a provision like that. It would be very rare indeed for you to be able to recover.
It's a very common question, though.
So generally speaking, yes, the participants have to front it up.